Good evening to one and all for this yet again third webinar. I take this opportunity to introduce Avhad sir. His full name is Advocate Sudhakar Eknath Rao Avhad. Sir has been practicing as a lawyer since 1977 and has been standing of 38 years. Sir has practiced in civil, criminal, revenue and cooperative sides with specialization in land laws. Sir has authored many books, and noted ones are Draftsman, Law of Notices, Judicial Services Examination, Real Estate Development and Regulation Act 2016. Sir has been a chairman of Bar Council of Maharashtra and Goa 2002 to 2003. Sir was a member of Bar Council of Maharashtra and Goa in 1998 to 2003. Today's topic on which he is going to speak is position of illegitimate child. Over to you, sir.
Good afternoon, my advocate sisters and brothers from all over India. I am really thankful to the office bearers of Family Court, Mumbai, and especially Shraddha Madam in this regard. Really, friends, we are at home nowadays and we have to take care being at home. Now, as the topic has been given to me, is in respect of legal possession of illegitimate Hindu children. This issue presently is pending before the Supreme Court of India for a decision by a full bench on reference in the case of Ravan Siddhappa versus Mallikarjun, and the issue has been referred to the larger bench in the year 211 only. Till today, there is no hearing in this regard and issue is pending before the Supreme Court. Before we come to various decisions and the present legal position, let us see what was the law in this regard during ancient period. What was the textual Hindu law in this regard? The textual Hindu law, as friends, all of us we understand, was and had been a personal law. Hindu personal law, it has been enshrined in the Vedas, Puranas, Upanishads, customs and commentaries. As per the personal laws of Hindu, the position of an illegitimate child was such a child and its legal position was not recognized. Such a child had no rights in respect of Hindu joint family. This especially was so because in those days the proprietary matters amongst Hindus were regulated by the Hindu law as provided in Vedas, provided in Shrutis. If we read Manusmriti and some part thereof, then we'll realize that the status of illegitimate child was of such a nature whereby he had or she had right to maintenance only from his or her father and mother. However, the law has been changed since independence. After independence, the government of India had constituted a committee called as the Hindu Code Bill Committee. The purpose of the Hindu Code Bill Committee was to codify the textual Hindu law so as to provide for proper legislation in this behalf in clear terms. The Hindu Code Bill Committee was acting under the chairmanship of jurist B.N. Rao. He was great constitutional jurist and afterwards became the judge in the International Court of Justice. Under his chairmanship, codification started, but because of the political aspects and resistance from the Hindu community, such codification could not be completed. Instead of making Hindu law as a single law, it was provided that instead of comprehensive law, it was decided that there should be piecemeal legislation. And such a piecemeal legislation took place in the form of 4 laws, as friends we understand. Firstly, the Hindu Marriage Act of 1955, the Hindu Succession Act of 1956, the Hindu Minority and Guardianship Act of 1956, and the Hindu Adoption and Maintenance Act of 1956. All of us we know that by these 4 legislation, what has been done is only 4 branches they have been codified. Only marriage laws, succession laws, adoption and maintenance laws, the provisions in respect of Minority and Guardianship Act, they have been codified. Rest of the law is not codified. It is to be found and that is to be borrowed from the textual law only. How it is so borrowed, we'll discuss under Hindu Marriage Act and especially section 4 thereof. The Hindu Marriage Act of 1955 came into existence on 18th May 1955, and thereafter the law as to marriages came to be changed in India with reference to Hindus. Especially the Hindu Marriage Act is to be understood at the outset. At the outset, we have to understand section 3 and section 4 thereof. Let us friends see few definitions from this act. To understand this law properly, to understand its different aspects, let us see few definitions. Few definitions they provided in this connection that firstly, agnate, cognate, full blood, half blood, uterine blood, related, and an heir. To understand such few aspects, first let us see who are agnates. In respect of succession matters and in respect of marriage issues, it is necessary to understand these different definitions. Especially in section 5 of the Marriage Act, it is provided that they shall not be subpindas of each other. They shall not be so related within the prohibited degrees. Otherwise, we know the consequence thereof. We know such a marriage becomes void under section 11 of this act. And therefore, let us see this definition at the outset. Without entering into the arena of today's subject, let us see what is this issue as to this aspect of these few definitions. The term agnate has got a simple meaning. The term agnate means such heirs, such persons who are so related, having relationship or descending from the same common ancestor through male relationship only without any female intervention. While cognates are those heirs or those relations who have been descending from the common ancestor, but through the intervention of the female, that is the blood relationship which is not wholly through male only. That is cognate relationship. Then there is full blood relationship. Full blood relationship means such a relationship wherein there is a common ancestor and such common ancestor and his wife, such children begotten from them, they are said to be from and having full blood, like real brothers, real sisters. So, same father, same mother, and therefore they are said to be real relations called as full blood. However, there is a half a blood relationship. Half a blood relationship means there is same father, but there are more wives, and such children of more wives from the same father, they are related to each other by this relationship as to half blood, as we call in Hindi as Sautele Bhai, Sautele Bhai. Then comes uterine relationship. This is a special form of relationship wherein there is the same woman, there is the same mother, and there are more husbands. And she had begotten children from different husbands at different times. If, for instance, a woman was married to a man, she begot a child, a son. Thereafter, there was a divorce or the death of her first husband. Then she married to second husband, and therefrom she got another son or a daughter. Then these two from the same woman but from different husbands, they're called as uterine relationship. And lastly, the word related. The term related as defined in section 3 of this act means such a relationship through legitimate kinship. Then such issues, they are answered accordingly. In this law, there is very interesting provision made in section 4. This section 4 is almost common in all the 4 legislations just now we have discussed. Just now we have said in these 4 laws, the modification has been done, codification has been done, changes have been made, and they are statutory changes. Such statutory or codified changes, they provide in section 4. Section 4 is very vital, friends. Whenever you take up for reading or discussion any of these 4 laws, never forget to read section 3 and section 4. Section 3 provides for definitions, while section 4 provides for the overriding effect of these 4 laws. That is how thousands year old Hindu textual law is on one side, and these 4 pieces of legislation are on the other side. This other side law, it overrides the ancient textual law which stood the test of the time for thousands of years. Let us see how by one stroke, how by few lines, the Parliament of India provided for overriding effect of these newly drafted and enacted laws. This magic, friends, is to be found in section 4. Let us see what is section 4. Section 4 has got 2 parts. Section 4A and section 4B. Let us see what is section 4A and B. Section 4A, it provides that any rule, any text, or any interpretation of Hindu law, or any custom or usage of Hindu law having or being in force immediately before commencement of this act shall cease to exist insofar as there is provision made in this act. What it means we'll discuss. While subclause B says that provisions in any other law shall cease to apply to Hindus insofar as they are inconsistent with the provisions of this act. Let us see the magical words used by the Parliament very precisely. Section 4A provides for the relationship between earlier Hindu law and this statutory Hindu law. The earlier Hindu law, it did consist in 5 aspects. Firstly, any usage or any custom or any rule or any interpretation or any text of Hindu law. Therefore, that is all. Hindu law or ancient Hindu law, it could be in either of 5 things, these 5 elements. And therefore, it is said that Hindu law contain in all these 5 aspects, it now shall cease to apply to Hindus. When? Not always, not all those textual laws, to the extent that there is a provision made in this act to that effect. Therefore, if it is so provided in this act, then earlier law shall not be applicable. It shall cease to apply. It shall cease to apply to the Hindus to that effect. This application of law to the Hindus is regulated now by section 4A. While section 4B has different aspect. Section 4B, it has different aspect in as much as section 4B now provides that any provisions in any other law. So section 4 related to only section 4A related to provisions in Hindu law. While section 4B now relates to provisions in any other law. So provisions in any other law, they shall cease to apply to Hindus. Let us see the difference between these two Caesar. In the first instance, it is said such provisions in Hindu law shall cease to exist. But in the second part, it is said they shall cease to apply to Hindus. Let us try to understand the scope of subclause A and subclause B. In respect of subclause A, we understand that in subclause A, what happens? Such any text, any rule, any interpretation, any custom or usage, it ceases to exist. Whenever there is express provision made in this act, such earlier law ceases to exist. That is not in existence anymore. However, in respect of subclause B, this does not happen. In respect of subclause B, that ceases to apply. Law is in existence. That law is already in existence. That will apply to other religions, but that will not apply to Hindus. So, it being in existence, application is restricted in respect of Hindus insofar as provision is made in this act to that effect. Once this is done, then we come to the next part. The next part is in respect of now the present aspect with reference to illegitimate children or today's subject. So this was just a background to understand it. And to understand today's subject, we have to also understand what is provided in this law, in this regard, in Succession Act. Say friends, in Succession Act we will find a little different story. In section 3 thereof, again there are definitions provided as to agnate, as to cognate, and other definitions as just now we discussed. And the last definition is provided in section 3, subclause J thereof. And in subclause J thereof, they provide for the definition of such related. Person so related means there is a relationship arising out of legitimate kinship. And below that, there is a provision made. I presume that everybody is hearing properly. Then the issue arises in this connection. Below section 3(1)J, there is explanation provided, and that is with reference to illegitimate children position under Hindu Succession Act. Apparently, there is a contradiction between Hindu Marriage Act and Hindu Succession Act. Hindu Marriage Act is differently stating such position, and Hindu Succession Act is stating this position with little difference. Let us see the difference first. This explanation below, section 31J says that in case of in Hindu Succession Act, section 31J, that in case of an illegitimate child, he will succeed to his mother, and such child and his other relations, means his brother, etc., they will be heirs of one another, but they will not succeed to others. So let us first understand what Hindu Succession Act has laid down. As per section 31J, Hindu Succession Act specifically says in case of an illegitimate child, he will succeed only to his mother or her mother and not to others. They will not succeed to other relations. They will not inherit property from other relations. However, in case of Hindu Marriage Act, there is a different story to understand. And to understand this different story, we have to now go to section 16 of the Hindu Marriage Act. Section 16 of Hindu Marriage Act is divided into three parts: section 16.1, section 16.2, and section 16.3. To understand section 16.1, section 16.2, and section 16.3, we have to understand the consequences. Yes. I hope that everybody is listening me properly. Shraddha madam, everybody is listening me properly. Hello? Hello?
Yes, sir, you carry on.
Okay. So, in the first instance, yes, I'll carry on. In first instance, we have to understand section 5. Section 5 of the Hindu Marriage Act of 1955, it provides for essentials of a valid Hindu marriage. There are 5 essentials. Previously, there were 6. By marriage arrangement amendments of 1976, now there are only 5 amendments left, 5 provisions left. To be a valid Hindu marriage, first, there must be no spouse living. Secondly, there must be valid discharge of consent. ABC 3 clauses are given. Then thirdly, they must attain that age of marriage. And fourthly, they must not be subpoenas of each other. And fifthly, they shall not be within prohibited degrees of relationship. Therefore, section 5 provides for essential conditions for a valid Hindu marriage. Once these essential conditions of valid Hindu marriage are prescribed, then other laws are applicable. In case of a relationship arising out of marriage, that will be regulated. In respect of death of the parties, then heirs will be inheriting the property as per the provisions of the Hindu Succession Act of 1956. However, the difficulty arises that if conditions are not fulfilled, marriage has been performed, the ceremonies have been undergone. However, the marriage is not validly performed, means the parties, either of the party is having the spouse living. Either earlier husband or wife is alive, irrespective of that, he or she enters into a second marriage. This is called as a bigamous marriage, we understand. Then out of this marriage, if a child is born, what shall happen? What shall happen to such a marriage? And then we understand it has been declared under section 11. If any marriage has been solemnized, which is in contravention of subclause 1 or 3 or 4 or 5, then such marriage becomes void. What are such 3 causes? First is what? If such marriage is in contravention of 3 things, firstly, it is spouse is alive, or there is a subpoena relationship, or they are within prohibited degrees of relationship, then marriage will become void. If marriage becomes void means what? Under section 11, if marriage becomes void, then such marriage is null and void. It is void ab initio. When that has been so performed, since then the marriage is void. If out of such void marriage, child is born, what shall happen? Or marriage is voidable under section 12. Marriage becomes voidable under section 12, subject to those conditions stated in section 12. And voidable means this is not a void ab initio, but if either party at whose option the marriage is so voidable may seek a declaration from the court for that marriage be annulled because of these contingencies as stated in section 12. In the meanwhile, there was a child born. Then what shall happen to such a child? One of the Western philosophers has said, the question of illegitimacy, it does not arise. It is not in respect of illegitimate child. He has very precisely said that is, it is in respect of illegitimate parents and an innocent child. So children are not innocent, children are not illegitimate, parents are illegitimate, and the children are innocent. And therefore, so as to protect such innocent children, almost all countries in the world, they have made their own laws. Similarly, in India, we have made our law, that is, law in the form of section 16.1, section 16.2, section 16.3. Let us see what is section 16.1, section 16.2, and section 16.3. I will ask Shraddha Madam to refer to those sections with reference to PPT point presentation, please. So you will find there are three aspects in section 16.1, section 16.2, and section 16.3. Especially section 16.1 relates to, if you read it properly on the screen, then section 16.1 relates to nullity of a marriage by virtue of application of section 11. If by virtue of application of section 11, marriage is void. It is annulled marriage. Marriage is annulled. It is declared as void. Then, in the meanwhile, if any child is born, what is the fate of such a child? Secondly, section 16, subclause 2 relates to section 12. That is in respect of voidable marriages. If decree for such voidable marriage is for declaration that it is nullity is called for in the court, it is prayed for in the court, and such a decree has been passed. So marriage is annulled. Marriage is declared as void. In the first instance, void ab initio. In the second instance, from the date of the decree of the court. In the meanwhile, the issue arises if child is born, whether such a child is legitimate or illegitimate. And in both of these two sections, as is visible from the text which you are viewing on the screen, such a child is declared to be legitimate. And the consequence thereof is stated in subclause 3 of section 16 of this Act. This section 16.3, subclause 3, provides for the consequences of such declaration of legitimacy. Friends, let us stop here and let us see what sort of provision it is made in section 16.1, section 16.2, and section 16.3. Friends, this is nothing but a legal fiction. Technically speaking, legally speaking, practically speaking, are they legitimate? In fact, they are not. Even though they are not legitimate, irrespective of that, law says that they are deemed to be legitimate. Illegitimate children are deemed to be legitimate. This is fiction of law for the purpose of conferring protection and benefits to such innocent children. At the folly of the parents, they shall not be sufferers, and hence there is a deeming provision made. There is a fiction of law created. They are protected. But let us see the nature of the protection. They are protected. They are declared to be legitimate. Even though they are declared to be legitimate, subclause 3 provides for the consequences thereof. And what is the consequence? As Shraddha madam is showing you on the screen. Subclause 3 relates to the entitlement of such illegitimate children. Let us see to what extent such illegitimate children are entitled to such a protection. Such illegitimate children are entitled to the protection to that extent. What is the extent? The extent is legitimate child is entitled to the property of the parents only and not entitled to succeed to others or other persons, other heirs of the deceased. Therefore, there is a limitation and a restriction that such a person, such heirs, illegitimate children, they can be heirs only to or sharers only to the extent of the property of their parents. So here is the dichotomy made. What is the dichotomy? What is the distinction made?
Rohan, you there online? Hello? The voice is breaking. Not here.
Hello.
Hello.
Siddha?
Sir, let me see. Let me check. Wait, wait.
Huh?
You are now unmuting.
Hello. Hello.
So,
Hello.
hello.
Rahul.
Yeah, just a minute. Um, uh, Avhad sir, please, yeah, share your camera. Yeah. So, your voice, your mic, I think you are on mute, sir. No.
Okay.
Yeah, you are audible now, sir.
Okay. May I start now, please? Thank you. So, friends, Radha madam, it is all right now?
Yeah, she's joining back, sir, in 2 minutes.
Rahul, just allow me to share the presentation, please.
Yeah, sure, ma'am.
Yeah, thanks.
So, from the screen, as it has been shown to you by madam, section 16.1, section 16.2 we have discussed. Now, let us go to section 16.3 from the text that is visible on the screen now. And as per section 16.3, illegitimate children, even though they are deemed to be illegitimate by fiction of law, nevertheless, such illegitimate children are entitled to property, are entitled to inherit, entitled to succeed only to the property of their parents. And therefore, they are entitled to such limited, restricted property is the provision made in this behalf. This term property, as visible in section 16.3, was the cause of further litigation and uncertainty. This issue had been before the Supreme Court. Let us see, friends. Let us see where is the discrepancy. Let us see what was the cause of the debate and dispute. Debate and dispute was that in section 16.3, it is stated they are entitled to succeed to the property of their parents. Which property has not been stated, whether it is self-acquired, whether it is ancestral, whether it is separate property, nothing has been stated. Only statement is made by the law, by the parliament, is property of the parents. And this is the bottom line of the dispute pending from 1996 to till today in the Supreme Court. First case on the point was before the Supreme Court in the year 1996 itself. That was K. Kalyani Amma versus K. Devi, as is visible from the screen itself. This case was decided by the Supreme Court in the year 1996. 1996, volume number 4, SCC, page number 76. In this case, the constitutional validity of section 16.3 was challenged. Section 16 rather was challenged, and that was based on the consequence in respect of why such illegitimate child shall not be entitled to the co-parcellary property, why it shall be restricted only to that extent. The Supreme Court upheld the constitutional validity of section 16, and that has been so said by the bench the division bench in Kalyani Amma's case that it is a social legislation that relates to socio-economic conditions, and therefore such term, such issue, such provision shall be interpreted by the or with the help of and with the aid of beneficial interpretation rule of interpretation of statutes. And therefore, when beneficial interpretation rule is made applicable in such a case, then such provision is held to be constitutional. However, Supreme Court provided in para 82 of the judgment that the fiction of law is created hereby for all legal purposes. Such a child is deemed to be legitimate. However, the court shall not legislate itself when it has been said that such a child will be entitled to the estate or to inherit or to succeed to their parents only, then the court shall not go beyond that under any conditions. Hence, court observed in this case, court held in this case of Kalyani Amma right back in the year 1996 that such a child is entitled to inherit, but entitled to inherit only to the property of the parents. And my colleagues, friends, let us see, property of the parents means what? Property of the parents means his or her separate property. The restricted meaning was given by the Supreme Court in respect of such a term, meaning thereby it is limited estate, restricted estate, separate estate of such person. Rather, in this behalf, issues had been taken to the Supreme Court time and again. The first issue was taken before the Supreme Court in the year 2003 itself, and that was in the case of Jinia Keotin versus Kumar Sitaram, that was decided by the Supreme Court in the year 2003. Friends, it is visible on the screen as Madam is showing it to you. This case was decided by the Supreme Court in the year 2003. Issue was again in this case whether in this connection such an illegitimate child is entitled to be a co-partner, is he entitled to be member of the joint family, is he entitled to the share in the joint family property, or is entitled only to the separate share of his father and mother. It has been so held by the Supreme Court that such a child is not a co-partner, such a child is not entitled to the member of the Hindu joint family, not entitled to the Hindu joint family property, but is entitled only to the share in parents' property, father's share, or at the most mother's share. Such issue was answered by the Supreme Court. Issue was again before the Supreme Court in the year 2006 in the case of Nilima versus Sarojamma. In the year 2006, when the issue had been to the Supreme Court in this regard, the Supreme Court followed its earlier decision in Kalyani Amma. It further followed the decision in case of Jinia Keotin and held that the illegitimate child is not entitled to be a co-partner, is not entitled to be a member of the joint family, but is entitled only to the separate property of parents. The issue was again stated in clear terms by the apex court. Issue was lastly before the Supreme Court. In case of Bharata Mata, it being South Indian word, it is Bharata, B-A-R-A-T-H-A, Matha, M-A-T-H-A, Bharata Mata versus R. Vijaya Ranganathan, decided by the Supreme Court in the year 2010, Supreme Court. In this case also, Supreme Court reiterated and confirmed all its previous decisions in Kalyani Amma, so also Jinia Keotin and in Nilima's case. Finally, Supreme Court verdict came. What was the Supreme Court verdict? First, it is constitutionally valid. There is a fiction of law created. Such a child is deemed to be legitimate, entitled to inherit from his or her parents, but only his or her property and not the co-parcellary property, not the Hindu joint family property. This issue was finally settled by the division bench of the Supreme Court. All the lawyers, all the practitioners, academicians were thinking that that issue is now being settled. However, issue was not settled finally. In the year 2011, in case of Revan Siddhappa versus Mallikarjun, in case of Revan Siddhappa versus Mallikarjun, the case was decided by the division bench of the Supreme Court. The bench was comprising of Justice Singhvi and Justice A.K. Ganguly of the Supreme Court. This case has been reported as it is visible in the screen being shown to you and has been reported in 2011 Supreme Court, volume number 11, page number 1. And therein the bench differed from the earlier views. This division bench said that this is the beneficial legislation. As it being the beneficial legislation, what is to be done in this behalf? What is to be done in this behalf is simple. What is to be provided is simple. The legislation shall be interpreted in such a way that full justice must have been done to them. This is so as to improve their socio-economic conditions, and if their socio-economic conditions are to be improved, then so as to accomplish the purpose, we have to give full justice to the provisions. The honorable judges of the Supreme Court, Justice Singhvi and Justice A.K. Well, both of the judges were of the view that in such a case, full justice must be done. They are the legitimate children. They are legitimate children by virtue of fiction of law. Not only this, but they must be held to be entitled to the co-parcellary property also. They must be entitled to the share of the co-parceller in the property. However, by words of precaution, they stated, true it is that such an illegitimate child, even though entitled to inherit the share of his father or mother in respect of such co-parcellary property, nevertheless shall not be entitled to claim partition during the lifetime of father. By imposing such a restriction, all other provisions were made applicable in this case. However, in this case, the division bench of the Supreme Court, Justice A.K. Ganguly and Justice provided in this case, they made a reference to Chief Justice Honorable C.J. Kapadia, sir, in this case, and they said, refer this issue to a larger bench, that is a full bench of the Supreme Court, because there are different views expressed by different division benches of the Supreme Court. This issue, therefore, needs to be settled by the full bench of the Supreme Court. This was the reference made by the division bench in Revan Siddhappa's case to the Chief Justice of the Supreme Court. Reference was made in the year 2011. However, from 2011 till 2019, there was no such issue has been decided by the full bench of the Supreme Court. It took about 9 years to decide the issue. Recently, very recently, in the year 2019, there had been a matter before Honorable the division bench of the Supreme Court. This division bench of the Supreme Court, comprising of Justice Bose and Justice Uday Lalit of the Supreme Court, they were to decide the same issue, whether an illegitimate child or illegitimate son is entitled to the joint family property or not, whether such a child is entitled to the co-parcellary property or not, or whether the term property as has been used in section 16.3 is used in restricted sense or not. These two judges Honorable Justices of the Supreme Court, they are of the view that what has been decided in the case of Revan Siddhappa is to be followed. However, they said that as there are inconsistent views expressed, and they further say that as the issue has been referred by the Chief Justice to the full bench, and so far full bench decision has not been delivered, issue is inconclusive, and therefore they have stayed the matter indefinitely till the decision of the Supreme Court by the full bench in respect of the reference made in Revan Siddhappa's case by the to the Chief Justice, and accordingly when the full bench will decide the issue, matter will be conclusively decided. Till then, friends, issue is very simple. Let us see what is the present position. Present position is with reference to Kalyani Amma's case decided by the Supreme Court in the year 1996. Such a child, such an illegitimate child, is entitled to inherit by fiction of law. There is a deeming provision. Such illegitimate child is declared to be legitimate. Such innocent child is declared to be legitimate. Therefore, there is a full legal status is confirmed. As far as status is confirmed, there is no division, there is no difference of opinion in the minds of the Supreme Court justices. So, as to status, they are of the same view. They are of the one view. However, there is a difference of opinion in respect of the proprietary rights. One view, as has been expressed in Kalyani Amma's case, in case of Jinia Keotin case, in Nilima's case, and Bharat Mata's case, is that they are entitled to proprietary rights only to the extent of. They are entitled to such proprietary rights only to the extent of the parents' property, parents' separate property. However, the judges in Revan Siddhappa versus Mallikarjun are of the view that such property, the term property used in section 16(3) shall not be construed in a narrow sense. There shall be a wider meaning given to it. And the wider meaning shall be, it shall be not only separate property, but it shall be ancestral property also. So, to conclude, we can say that as per the latest case of Revan Siddhappa versus Mallikarjun, the illegitimate child is entitled to full legal status as well as full proprietary rights. And this is so with reference to the provisions incorporated in Article 39 of the Constitution of India. Therefore, in respect of this, there is a provision made in respect of proprietary rights of children in the Constitution in directive principles of state policy. Friends, here therefore, full justice has been made to them. Earlier, what was done? What was done by the Supreme Court decisions? That on one side, the legitimate, legally legitimate and deemed legitimate by fiction of law, full legal status was the same. However, in respect of proprietary matters, there was a difference. However, by Revan Siddhappa versus Mallikarjun case, this difference of opinion, this difference of status has been put to a full stop. However, we have to wait and see what the Supreme Court will decide. In my opinion, in my honest opinion, considering the constitutional provision, there shall be equality before the law, and this equality before the law is that once we say that such illegitimate child is said to be legitimate, then is it legal? Is it constitutional to say that such legitimacy is confirmed only in respect of a legal status, and such legitimacy is not confirmed in respect of proprietary matters? And therefore, friends, if we apply the constitutional test, then my opinion is that in such a case, once it is a deemed consequence, if it is a fiction of law, then as a consequence of the fiction of law, there shall be the full equality, absolute equality. By such a deemed consequence, there shall be deem equality in respect of legal status as well as proprietary rights also. Then we'll come to the next point, friends. The next point is not so far discussed in any judgments. Let us see, this new point will come before the Supreme Court in the full bench reference. In this full bench reference, this new point will arise, or rather should be raised by the arguing counsels, senior counsels. You'll find in the year 1986, there was a case decided by the Supreme Court. That case was the Commission of Wealth Tax versus Chandar Sen. Case arose from Allahabad High Court. And in Allahabad High Court, the case was decided, ultimately was and had been before the Supreme Court. And the Supreme Court, in this case, in the year 1986, held that whenever the provisions of Section 8 are applicable, when a person dies, being the member of the co-parcenary, as soon as he dies, Section 8 comes into operation. When Section 8 comes into operation, then property in his hands becomes his separate property. Friends, therefore, after 1956, that means after 17th June 1956, that is the application or the operation of the Hindu Succession Act of 1956, all properties in the hands of such a person, when there is a death occurring in the family, all his heirs, all his sons, they are getting the property as their separate property. If this is so, if it becomes his separate property, then even under earlier law, and earlier law means Kalyani Amma's case, earlier law means Jinia Kyotin's case, earlier law means Nilima's case, and earlier law means Bharat Mata's case. In all these cases, by virtue of application of Section 8, such an illegitimate child, under even earlier view of the Supreme Court, shall be entitled to the full rights, it being the separate property, it being the deemed separate property by virtue of application of Section 8. This issue has been very recently confirmed. So the last point to be discussed, sorry for the interruption, it was for the net correction. We resume it now. So the last point remains here, that whenever there is application of Section 8 of the Hindu Succession Act, as soon as there is a death after 17 June 1956, then the property in the hands of the heirs, it becomes the separate property, and as soon as it becomes a separate property, the heirs, they are entitled to it as a separate property and absolute owners thereof. As soon as they become absolute owners, the heirs are entitled in their own capacity. Hence, in case of application of Section 8 and the recent judgment of the Supreme Court in case of Rohit versus Surendra Kumar, Uttam versus Saubhag Singh, reported in 2016 Supreme Court, then the judgment delivered by Justice Nariman very clearly states that such a property in the hands of the heirs becomes a separate property. If we read Section 8 of Hindu Succession Act along with the provisions in Section 16.3, then irrespective of the new judgment to come, the full bench judgment to come, even by virtue of the old judgment, we can argue before the court that we are entitled to the absolute property and the property of the co-parcener in the co-parcenary and in the Hindu joint family. So these are the concluding remarks. With this, I have to conclude myself. If there are any questions to be put, kindly put such questions to me.